So today, that's all we do, man. All we do is we help real estate syndicators not just bang out a bunch of docs, right? So that's one of my biggest pet peeves. It's not just about, hey, I need docs, I need a PPM, I need this, I need that. No. You need to make sure that you're raising capital in full compliance with both federal and state securities laws, making sure all these little things that pop up where, whether it's compensating people to raise money, whether it's a joint venture or if it's a syndication, whether, whatever you're doing on social media, whether you're doing a fund of funds, are you an investment advisor, all that stuff is part of the compliance. And so that's kind of all we do now. We exclusively focus on our real estate investor clients.
Tim is one of the most authentic and genuine people I've ever met.
I sincerely believe he's coming from a position of giving, and that means a lot.
You're going to make huge progress.
Welcome, everybody, to today's Capital Raising Show. I'm your host, Tim Mai, and today we have a super special guest. He's the very first guest that we have on that doesn't have to do with directly raising money. However, he is the legal counsel, Mauricio and his team, legal counsel behind over $5 billion worth of capital raised. That's a lot of money. It's a lot of, gosh, how many zeros that is, but a lot, right? Mauricio Rauld is the founder of Premier Law Group, which is a premier syndication attorney in the country that helps real estate syndicators stay out of jail. Mauricio is one of the few lawyers that actually speaks English when it comes to real estate legals and and syndications. He regularly travels around the country speaking to real estate syndicators about how the legal piece fits into the overall syndication puzzle. And he has shared stage with the likes of Robert Kiyosaki, Ken McElroy, Brendan Turner, the real estate guys, and he's been on so many different stages. So let's give Mauricio a big welcome, y'all. Woo-hoo!
Hey, thanks for having me, everyone. That's quite an intro. I appreciate it. I'm looking forward to hearing what this guy has to say.
Me too. That makes the two of us. So awesome. Mauricio, share with us a little bit about you and how did you get into this whole world of syndication law?
Yeah. So about me specifically, I'm the proud husband of my amazing wife Heidi, and I got two little girls. So that's really the main thing I do. I'm a father and a husband. But for work anyway, I help syndicators, real estate syndicators, primarily stay out of jail. And I know that's like a little bit of a harsh or funny statement, but I just found that a lot of people just don't take these securities laws that important. But look, I go way back. I did the traditional route. I went to school. I went to undergrad at UC Berkeley, went to law school here at Loyola, and then I did what every lawyer dreams of doing, which I went to work for a relatively large law firm in Long Beach, California. Where I did a lot of securities and we're right next to the port of Long Beach. So we did a lot of maritime as well, but I was on the litigation side. So I would represent a lot of these securities brokerage firms like JP Morgan, Merrill Lynch, American Express, Goldman Sachs, and we would defend them. They would get sued. Usually it was a little bit more garden variety, stock market stuff or investments gone awry, but the world was litigation. So I was responding to complaints, depositions, broad trials, motion, all that fun. I spent court, a lot of time in arbitration. So I have that skill set. It's really a skill set more than anything. But, after about 4 or 5 years, it just didn't seem like it was really the right path for me. And I just felt that there was something more out there than just clocking in every day and working all day and night and all weekends and billing every 6 minutes of my life and not having time to do anything else. And fortunately for me, just like a lot of your listeners, I came across that little purple book, Rich Dad, Poor Dad. I don't know what year it was, would have been probably 2004, 2003, something like that. Maybe 2004, probably 2004. Long story short, that book, like all of you guys, probably just blew me away. Read it on the plane ride back from New York, and it was just a mind shift, and it made me realize was wrong, or there was more that just justified that. And so that, separate and apart from the book itself, I think, because I think maybe the book I would have eventually gotten to, if it wasn't on that trip, I would have gotten to it later. But what was really serendipitous for me was literally a couple of weeks after I read the book, I was driving down in LA where I lived at the time, and Robert Kiyosaki comes in on the radio. Back then we listened to the radio. That's how old I am. But we were listening to the radio, and he had a radio ad, what we call a drop-in for the real estate guys. And so he had a great, and I still to this day have it memorized. He said, hey, this is Robert Kiyosaki, author of Rich Dad, Poor Dad. If you're serious about investing in real estate, check out the real estate guys. They really know what they're doing. And I was interested in real estate. So if it wasn't for that ad, meaning if it wasn't for the book I'd read, if it wasn't for the ad, I wouldn't have gotten and ended up going to the seminar that I went for the real estate guys, which is what really ultimately changed my life, because very shortly thereafter, they approached me. I was interested in coming to work for them in-house as the general counsel. And that's really where I cut my teeth on syndications. They were, 20 years ago now, maybe not that far now, 17 years ago, they were doing a ton of syndications, raising capital. Old school though, guys, forget about this Zoom and webinars. I mean, this was like, we would put together events, live events, physical people, 70 people in a room. We'd dress up in suits and ties. They'd always wear their white, kind of like I am now. They'd wear a white shirt because whenever they were looking for money, they would wear a white shirt. And then they would do a pitch, a presentation with a PowerPoint live. And then we'd have all the PPMs printed out. Can you imagine that? Printed out all the PPMs. People were writing checks. I was there collecting the monies and answering questions about the PPM. Wow. Really old school, right? But that's how I started. And then, that led to sort of me thinking about starting my own firm at some point. I was helping a lot of the members that they had, doing some asset protection, all that fun stuff. So long story short, I decided to just start my own firm, Premier Law Group. I officially filed it in 2006. So I don't think I really started using it until 2007. But I kept the real estate guys as obviously a VIP client, but then I started helping out all of their members, primarily with asset protection, LLC formations, stuff like that. But then also syndications. And let's be honest, anything else somebody wanted me to do, I was like, yeah, I'll draft a contract for you. Like whatever puts food on the table, I was game. But over the years, I just kind of narrowed my focus. And I think it was when my daughter was born. So this would have been 7 or 8 years ago. I just made a decision that I was going to go all in on syndication and exclusively practice syndication. It was, long story about how I came to that decision. But, and so for the last 7 or 8 years now, I've been doing exclusively real estate syndications. And all of our clients are real estate investors. And I kind of caught that syndication boom. We're kind of in this boom that probably started around 2015. That's right around when I started doing it. It just kind of took off. And so that's what I've been doing full time now since 2007, let's say. And then as you guys, I don't know if many of you know, but I got really, really sick back in 2018. So I got really sick. I ended up spending a lot of time in the hospital. And what I realized back then, I think is a good lesson for everyone, is that I was a single point failure. I was running a solopreneur. I was a solopreneur. I was a law firm. I was the only attorney. I did everything. I was a secretary. I was the assistant. I did all the paperwork. I hired a couple of, VAs, but it was me. And so when I got sick, that really crippled the business. Without me, the business went to zero. And so that just kind of was a good lesson for me. So once I recovered, I just made this goal. And I said, look, I need to go build a self-sustaining business that runs on its own, that if this ever happened again, I wouldn't be out of revenue. I actually have a team now involved. And that's kind of where I've evolved to today, where, we've got several lawyers, paralegals. We have a big team now, not a big team, a nice sized team, that if that ever happened to me again, my partner Bethany, which I think you've met, she's amazing. And so she's there to help out. So today, that's all we do, man. All we do is we help real estate syndicators not just bang out a bunch of docs, right? So that's one of my biggest pet peeves. It's not just about, hey, I need docs, I need a PPM, I need this, I need that. No. You need to make sure that you're raising capital in full compliance with both federal and state securities laws, making sure all these little things that pop up where, whether it's compensating people to raise money, whether it's a joint venture or if it's a syndication, whether, whatever you're doing on social media, whether you're doing a fund of funds, are you an investment advisor, all that stuff is part of the compliance. And so that's kind of all we do now. We exclusively focus on our real estate investor clients.
Gotcha. Well, before we dig into the differences between just docs versus full compliance, I'd love to hear how the syndication space has evolved since you first got introduced to the space. Because I haven't been in this space for very long, only a year and a half, and so I don't know a lot about it. But I heard the law changed a lot in 2012, correct? And syndication got more popular as a result of that. So share with us, give us a little bit of background.
Yeah, so I think from just a physical standpoint, like I mentioned, like back in the day, back in 2011, before the changes, like I said, there was no Zoom. I don't even know if Zoom was around. So there was really no ability to do all this sort of social media was just starting out, but not everybody was on social media. So the way you literally got to meet people and pitch your deals was through actual seminars, live seminars or live meetups where people physically congregated everywhere, which obviously limited you a little bit because you were obviously limited to whatever area you were in. But to your point, in 2012, a few years after the great financial crisis, if you guys recall back then anyway, all the financing just froze up. Like it started with mortgages, but really there was just no money flowing around. People were just uncomfortable investing and with their money. And so the Congress passed the Jobs Act in 2012, which its intent was literally to loosen up the rules because it was so hard for people to raise money after the whole financial crisis. And that led to the creation of what we kind of take for granted now, but it's this Rule 506C. Right back then, when I was doing presentations like I am today, but we only had Rule 506. There was no B and C. It was just Rule 506. Right, today is 506B. And I remember from stage saying, "Hey, there's new rules coming out, and we're just waiting for the SEC to, the Congress had passed it, but we were waiting for the regulations to come in, and it took a while. And I think it actually happened in 2013 when they finally passed in September of 2013. And finally, you had this ability to go raise capital from people you did not know. Not only was that a new thing, but when you think of it, it actually doesn't make any sense because they're supposed to be private offerings, right? Like if you're going to go public and go advertise, that's a public offering. You're going to go do an IPO, you're going to go public, right? This is a private offering, yet you can advertise. And it's like, okay, it's a little bit weird, but you're right. That is actually what I think started this idea that you can now, even if you didn't know anyone, you weren't relegated to just the people that you knew in your circle of friends and family and people that you met at meetups and at seminars, but you now could actually use social media, which started to blow up early in by 2014, 15, 16, Facebook and Instagram and all these other ones really blew up. And so more and more people to where it is today, where I don't even feel like I need to go to events because if you use social media properly, and I think the best capital raisers, and that's probably not a term I should use, the best syndicators do is they're actually it's almost like you're walking into a room and there's already a bunch of people. They just happen to be online. And if you actually engage just like you would at a webinar, or sorry, at a seminar or at an event where you're coming up and meeting and shaking hands, oh, what's up, and speak. If you're doing that on social, which doesn't mean you're just posting, it means you're acting and you're commenting on other people. They respond and you're really having conversations. And then people have gotten really good at that, and they've been able to expand their network. And that's, I think, what's led somewhat to the boom. Another thing that never used to happen, web, again, I don't think, I'm not sure Zoom came into the picture, in the old days, probably, I don't know, I think back even in 2017, people didn't do webinars. They already had their list. They'd accumulated a list somehow, whether it meetups or whatever. And so when they had a deal, the way they would pitch it is just by email. They would say, "Hey, I've got a new deal. Here's my business plan. Here's my thing." Only over the last 5 years have I noticed people using webinars as kind of some of their marketing tools, where they have a deal. Now they put together a webinar. They invite everybody to the webinar, pitch their deal. And the last thing I'll say that I've noticed has changed a lot in the last 3 or 4 years. Nobody back in, let's just say right before COVID, not nobody, but very few people had any of these platforms, right? You maybe had something like Syndication Pro, was kind of Juniper Square, maybe, but people would ask me, and I'm like, I don't know. Everybody's just using an Excel spreadsheet. Like there's nobody uses this portal. And now the portal world has just exploded, cash flow portals, InvestNext. I mean, there's so many of them now. And it's almost like if you don't have a portal, you're at a disadvantage because an investor compares your deal with somebody else. And it's like, well, why did they have a portal? We don't. It's gotten so bad or so good that even we at Premier Law Group have a portal. So all of our clients have their portal and they can get all their documents up there and upload them. And, we can communicate that way as well. And it's just part of people being more and more comfortable with the, the technology and all that stuff. So it's come a long way. I mean, as you know, I think I talked about it at your event, which was an amazing event that you had just a couple months ago. That this was a statistic from last year, so it's a little bit outdated. But last year, I remember reading the statistic that said that 70% of all syndicators, 7% of all syndicators had 3 years or less of experience. So there's a lot of people that have really come into syndication probably since around COVID, right? Maybe that was it. Maybe it was like, hey, COVID, I can't work, or I've got extra time. Like, what am I going to do? And they've started this whole thing of capital raising, which I do have my pet peeves with as well, because as syndicators, really your job is not necessarily to be a capital Your job is to be good at something, whether it's real estate, whether it's crypto, whether it's a business, or whatever it is that you're good at. And the idea is that you want to scale, you want to do more of, and you want to bring other people in. And so you raise capital to keep doing what bigger and better things that you end up doing. It's become more of an industry now where people are really just, all they're doing is capital raising, and they may not even know too much about the underlying project, but they're just good at raising capital. And we can talk about that as well.
Yeah, well, it's definitely, I feel like a whole industry is spawning of, niching into capital raising. And yeah, like I'm one of those people. And so I totally get what you're saying. And I think that too, COVID probably had a play in that. But I think that when the multifamily space hit the height of the market, the exposure for multifamily syndications was just so popular that I think it attracted a lot of people. And yeah, so like now in this industry and niching into the capital raising side of the business, I've gotten to learn a ton, and I gotten to learn, what to say, what not to say. I had an expert that I've been wanting to get on this show, and he's like, your show is called Capital Raising Party. I'm not gonna get on a. He's like, my attorney would not allow me to go anywhere near the word capital raising. So
There you go.
yeah, I totally get it. So let's talk about that, Mauricio. Let's talk about the difference between the legal paperwork, legal doc side of things versus the compliance side of things, because I bet that a lot of people think that, hey, if my legal is in place, then that in itself should be compliant, right? And so can you expand on what does it mean to be fully compliant beyond just having your legal docs being in place?
Well, your legal documents are the end result of the compliance, right? Just because, let me put it this way, if you've done all your compliance properly and you've checked all the boxes and you've run every single potential scenario and you've disclosed everything, then yes, your legal documents is what you need. But just because you have legal documents doesn't necessarily need you've gone through all that compliance. And that's kind of I don't know how to even explain it really well. I mean, the best I can do is, there is no black and white, right? So I think everybody thinks of like, oh, well, I've got this guy does a PPM, this person does a PPM. What's the difference, right? And the difference is really, I think, in terms of percentages. Like some PPMs are, it's hard to say something's 100% that every single thing has ever been caught, because a lot of times the clients don't reveal stuff. But let's just say one might be 99% compliant. And then this other one that you found off the internet or you did it yourself, that might be 50% compliance. And this one might be 65% compliant. So it's more of a range. And so, we have it's kind of like a checklist. So there's all these things, and it's not like it's not like I have a piece of paper in front of me every time we do a call and I just go through it's just I've been doing this for 23 years. So it's just in my head as we're asking these questions, like where are your investors coming? What are you doing? Who are your partners? What are your partners doing? How are you structuring this? How are you getting compensated? Who's getting like all these questions? As I listen to these answers, and our attorneys in our office listen to these answers, it's potentially, not always, can trigger something. Is that, oh, wait a minute. Oh, you've got 17 co-sponsors in your, okay. All right. So what are those 17? And we'll start digging into what are those 17 co-sponsors doing? And let's find out whether one of those or two of those are really not doing anything, or they're not doing substantial duties. And so, for example, that's one of the checklists that I have. It's like, nobody here, I think, nobody is registering as a broker dealer. I don't think anybody. I mean, there are a few. Every time I almost ask, and maybe there's one in the room, but nobody's a broker dealer. So the question is, what exemption are you relying on? And a lot of people don't even think of that, right? So as you guys should know by now, all of you that are raising money for syndications are relying. The reason you don't have to register as a broker and have a broker's license is because you have an exemption that you fall under, which is, it's kind of generally called the issuer exemption, although that's a terrible term because it's really not. The issuer is really the syndication company, but they call it the issuer exemption. And you fit into that as a syndicator, and there's reasons behind why you fit into that. But once you start having 4, 5, 6, 7, 10, 20, 30 co-sponsors, you start to have a hard time fitting into that exemption. And again, as a client, as a syndicator, it's not your job to know this. It's the job of the attorney to understand that, hey, the reason we don't have to go get a license because we fit under the issue exemption. And as long as there's 1 or 2 people, and there's 2 people doing this, they're all actually doing the work. But when you have 20 of them, there's a good chance that not everybody is doing substantial duties and all this, the stuff that you've heard of. And so that's just one of 1,000 examples of something that we as experience, remember, the reason we have that big number of 5 billion, it's not just all me, it's my partner, right? Bethany LaFlamme, who's my equal business partner. She's, I think, a year less than I am. So she's got 23 years of experience. I've got 24 years of experience. I mean, combined, we're almost at 50 years of experience, whatever it is, 47, 48 years. And so with that experience comes the ability to make sure that we're asking the right questions, and maybe more importantly, asking the right follow-up questions to understand what all the risks are in your deal, because that's your obligation. Your obligation is to disclose every single risk in the deal. Your obligation is to disclose stuff that, this is why the documents are important. Like, if you're violating one of these other rules, then you're not going to be disclosing that violation. Let me give an example. Let's just say you have too many co-sponsors, and it's determined that one of them is basically an unlicensed broker. Like they really don't fit into the exemption. So they should have registered as a broker, but obviously they're not a broker, right? You didn't put into your PPM, I'm paying Tim who doesn't have a license, right? You don't put that in your documents because, why would you? It's like, you're not assuming. And so that's an example of something that's how they're going to get you, by the way. Like if the SEC determines that one of your partners is an unlicensed broker, the way they get you is you didn't disclose that to your investors. You were making an illegal payment to an unlicensed. That would be the violation. That's ultimately how they're probably going to get you. And then obviously for the person on the other side, their penalty is really disgorgement, right? They got to return whatever they got paid plus penalties plus interest. And based on what we're seeing now on the crypto space a lot, it's usually double, right? So if you got paid the equivalent of a couple $100,000, then your penalty is probably going to be, you return the 200 plus another 200 in the form of penalties and fees. And anyway, we're just kind of rolling on a little bit, but my point is that there is a huge distinction between being compliant and then just banging out a bunch of docs. And that's why sometimes it takes a bit of time. It's not something where we just like, oh yeah, let's just, it needs time for us to understand your deal, go through, like we go through your business plan, for example. That's something I realize I don't think I don't want to say none of them do it, but I think a lot of attorneys don't do this. We do a deep dive. Like we don't underwrite your specific deal. It's like we're not double check sure that the asset itself is underwritten, but I'm going to take a really good look at your business plan. We're going to read that business plan line by line. We're going to have 1,000 questions, 1,000 comments, and we go through it, and we're going to go through a couple drafts. I'm going to say, hey, we need to change this, or we need this disclaimer, or this doesn't make sense. Can you clarify? And we're going to go down 2 or 3 drafts before we're comfortable and blessing that business plan. Pro formas, you'd be surprised. Look, I went to law. I'm a fairly intelligent guy, but I'm not a math wizard or anything. I'm certainly not. A lot of engineers in this room, and you guys know more about that. But just from experience going through their pro formas, and I look at the pro forma. A lot of times the numbers don't even add up. Like I'm doing the math, and I'm like, wait a minute, this doesn't. You forgot to add. You forgot to take out the pref over here, and you're double counting. And sometimes it's that bad, and sometimes it's just looking at the pro forma and seeing a trend line. Something suddenly pops and it's like, whoa, why did this go up in year 3? It was 5,000 and suddenly it's 8. Oh, it's because this happens. Oh, well, that's probably something we should disclose in the document, right? So just that ability to really ask you questions, because that's really how an attorney know how to do it, which is just to pepper you with questions so we can pull the information from you and we know what to put in the documents versus just you telling me what you think is important.
Right. Gosh, like my mind's going to so many different questions I want to ask you. But I'm going to try to attack it one at a time. So you mentioned the number 20, is there an actual number of co-GPs, before it becomes questionable that not everyone have a substantial role in the transaction? I've heard as much as 52 co-GP on a deal. So is there an actual number, or how does that work?
Chance on that. I used to cringe when I saw 7 or 8 or 9, and I used to cringe at that number. And now I've seen a couple where it's like 13, or I haven't seen. First of all, like, what are you doing? It's like you're going to get paid $1 from you. Well, there's not enough money to go around to split it between 20, 30 people. So I would separate. The first thing I would do is just a big number, right? Let's just say you have 7. Which is a big number. And I would separate those with, okay, how many of those 7 are not bringing any money in? because that's really the issue. It's not an issue that there's so many co-sponsors. It says how many of them are actually responsible for bringing in the money. So I would kind of eliminate anybody who's not on the sponsor team or the GP that's not. So for example, if I'm a KP, if my sole job is I'm part of the deal, they need me for the liquidity or the net worth, I'm going to lend you my balance sheet. And in exchange for that, I've negotiated 5%, 10%, 15% of the GP, right? I'm not bringing any of capital of outside investors in. I wouldn't count you. Like, you don't count in terms of what my analysis, right? But when it comes to people who are actually bringing in, I'm going to go with the number 5. And in terms of, and the reason I'm going to come up with number 5, because that's the number that the SEC has come out with in terms of joint ventures, right? It's similar to the joint venture argument, right? How many joint venture partners is too many? Well, in order for it to be a true joint venture, everybody has to be actively involved. If you have 20 people in a joint venture, somebody there is not actively involved. Now, this is a slightly different terminology. It's not meaning actively involved. You actually have to have substantial duties, but it's very similar terminology. And so after 5, it just gets, I'm not saying it's impossible. I'm just saying it's harder and harder anytime you get above 5 to show that all 5 of you are doing actual duties or are actively involved in the deal. And the higher that number gets, the harder and harder and harder it is to show. Now, is there a scenario that it's possible? Sure. And that's why you're always going to hear this term called facts and circumstances, which a lot of this is based on, which is there isn't some black and white number. It's not like it's 6 or it's 8 or it's 4. It's an analysis, and it depends on a bazillion different factors, which is why it's so difficult sometimes to come up with this, a final definite. Everybody wants a black and white answer, and a lot of times it's sliding scale. And what else are you doing? What are those duties? What else? So the SEC will always say it's a facts and circumstances analysis, meaning they're going to look at, the specific deal. And so that's why my analogy that I like to give is just think of you, and it doesn't happen this way, but I like it's a good image. You're sitting across the table from a regulator, and the regulator's looking at your exact situation, and they're asking these questions. That's how it really is going to work. Now, they're not going to be sitting across the table from you. It's probably going to be, via correspondence or through the lawyers or through phones or whatever. But that gives you a good idea. So, for example, one of the questions I like to just to illustrate this is if you have a regulator that's sitting across the table from you, and they're looking at your deal with all the co-GPs, and let's say I'm the main co-GP, and Tim, you're in the deal. And so the regulator is going to say, I see Tim Mai over here. He's a 5% owner of this co-GP. He didn't put any money into this. What did he do? What did he do in this deal? What is he doing? Your answer better not be so, he brought in the money. That can't be your answer. Your answer is going to have to be something else. And what is that something else? Oh, he's helping, he helped underwrite. He actually brought the deal to us. He actually underwrote this thing. He found it. He spent 6 months looking for this, and he found it. Or, oh, this guy's our top he's the underwriter. So once Mauricio brought in all these deals, he underwrites them, and he ended up picking these. Oh no, he's like you got to show something. And again, one person's fine, but when you have 10 of them, once you start going around the table, what did Tim, what did Sanjay do? What did Victor do? What did Daniel do? Like, at some point, you're going to run out of things for people to do. Not to mention, you're just getting diluted, right? I mean, how many people does it really take? Putting aside the capital raising part, just think about that. Putting aside the ability to bring capital, how many sponsors does it take to do a deal, a $5 million deal, $10 million? We're not talking hundreds and hundreds of millions of dollars, right? How many people does it take? 2, 3? Maybe it's like me and Tim, we're partners, but you know what? This deal's in Miami. And so we brought a guy in Miami because he's boots on the ground and he knows and he has, okay, fine. And maybe the 4th, because I don't know, maybe they found the deal for us. Okay. So fine. But 23, 50, what was your number? 54, 45? 52. I mean, unless it's $1 billion rate, I don't even know. I mean, they're going to end up with like $5 each, right? I don't know. That's just kind of I just think it's a hard story. At the end of the day, you've got to sell the regulator with this, whatever story you're going to come up with. It's going to be your burden to prove whatever it is you're saying this person did. And so just keep that in mind. It just gets really challenging, I think, at 5. That's why I always cringe already at 7 or 8 or 9. A 5 would be a good number to once you get above 5, you should be really taking a close look at what are these people really doing?
Right. All right. I know you're coming out with a course on fund of funds, and I think this is a perfect lead into that. So one of the strategies that a lot of syndicators are going, now that they're going away from the co-GP model, due to what you just shared about, they moved to the fund of funds model. And I had a lender that, share with me, well, I mean, that still looks suspicious if it's fund of fund where you're raising, one deal at a time and having one SPV versus you truly have a fund of funds, plural, where you have one fund that, its job is to invest into many deals. So share with us what's your take on that? Is it are we completely safe? Are we completely out of the question of too many co-GPs and not enough substantial duty in not substantial role, and now the fund of funds model, and especially doing SPV funds. So you're still doing this somewhat the same thing, but under a different legal structure. So give us some insights on that.
Yeah, so you're right. So what happened is people started to do this co-GP model, and there's a lot of people out there that just are really good at raising money, and maybe they don't have any other particular skill set. They're just good at raising money. They're good at relationships. They're good at internet marketing. They're good at putting out content. They're good at attracting. And so they started doing this co-GP model. I think the word's gotten out that they may not be doing it right. And so they've moved to a different model, which is a great model. So if you're somebody who's really good at raising money, then the fund of fund, or you're right, it maybe start separating the plural versus the singular, but let's just start in general. So the idea is, like, if you're really good at raising money, then why don't you just raise money into your own SPV, your own LLC, do that legally, fully complying with all the rules. And then let's start with the easy one. Then you have a $5 million, $10 million at the bank because you've raised money. You go out and look for the best operators you can find and the best deals and whatever, maybe you're into mobile home parks, maybe you're into self-storage, or maybe you're into a combination. Told your investors, maybe you're not interested at all, you're buying businesses, whatever it is. And then you go find and basically allocate capital, right? But you're vetting the sponsors. First of all, you're determining the asset class in general, but then you're vetting the sponsors. You're flying down, you're meeting with the sponsors, you're checking out their operations. And then when they do have a deal, you're like, oh, let me go look at the deal. Maybe you fly down and actually do the deal. So you're super comfortable that, hey, this is a great deal. I'm going to allocate $500,000 or $1 million of my client's money or my investors' money that is in the fund already. I'm going to allocate that to Tim's deal. Tim Mai's got a deal. He's raising $5 million. I've got a $10 million fund. I know Tim. I know he's really great. He's an awesome operator, and I know him. I've seen his operations. I look at the deal. I do my due diligence on it. I like the deal. Even better, I fly down, take a look at it, just make sure it's all good. And I say, Tim, I'm in for $500,000 or I'm in for $1 million. But Tim, I want some special privileges here because I'm bringing in $1 million. Everybody else is giving you $100,000. So, hey, forget about this 70-30 split that you're giving up. I want 80-20. I want to take, 80% of my, not 70. And maybe I want, whatever. I want a discount on this and more money. Somehow I can generate. That's how we generate more revenue for my fund, because I'm getting more from you. It's more like, hey, I have a seat at the table. Maybe you create this advisory board and I'm a part of that board. So my investors have, a direct ear to you, and maybe thoughts aren't gospel, but at least you're listening to my thoughts and what my concerns are and things like that. So all those things you're negotiating, that is a perfectly fine model. And if you're good at raising money, I think that's an excellent model for you to do. There's a couple more compliance things you've got to worry about, so that there are potentially some limitations to that. And so let me run through those, because one of the very, very subtle differences between investing in your own syndication, right, your own deal, versus investing in somebody else's deal, is that you go from investing in real estate. Let's just assume we're talking about real estate. You're investing in real estate to now, in a fund of funds model, you're investing in LP interest in somebody else's deal. That LP interest, which is technically a membership interest, is a security. It's just like buying stock in Apple or Microsoft or Google. I'm buying stock or LP interest in Tim's deal, right? So that means my fund is raising money pursuant to Reg D, right? 506B, 506C, Reg A, however we're going to raise the money. But now we're investing in securities, which is a big, big, big difference, because now all of these other statutes and rules and regulations, mostly at the federal, sometimes at the state, kick in. And so it's not the end of the world. It just means you need to make sure you have somebody, an attorney, that understands what these rules are, and making sure, again, that you fit into an exemption or you're complying with whatever the rules are. So it's not the end of the world. So the main one is that when this is the way the SEC looks at it, that the SEC looks at you, again, I'm picking on you, Tim, but like, let's say you've got your SPV, right? Your fund, your LLC. The SEC sees you, Tim, is advising your LLC, your SPV, as to the purchase of securities. That's how the SEC looks at it. You're advising your client is the SPV. You're advising your client as to the purchase of securities because you're investing in LP interest. That makes you an investment advisor, right? Again, not the end of the world. It doesn't mean you gotta, go through whatever. It just means you're an investment advisor. So then the question is, do I need to register anywhere, right? And the answer to that's fairly simple. If you, at the federal level, most likely not. Like, unless you've got $150 million in assets under management, we're not even allowed to go register at the SEC. And if you've got less than 25 million, it's even a clean. Okay, in between 25 and 150, it gets a little bit more complicated. But if you're just starting out and I want to put together a $20 million fund, you're considered a small potato, right? So you're not eligible to go to the federal level. So we look at the states. So then the question is like, Tim, where do you live? I live in Houston, Texas. So you're in Texas. Great. You are advising your fund in Texas. You're sitting in Texas at your office and technically you're advising your fund. So what does Texas say? Does Texas require you to register as an investment advisor, or does Texas have an exemption? And I know for a fact, just because so many people live in Texas, that Texas has an exemption, and it's a fairly simple one. All you've got to do really is make sure that you do not take investors into your fund. So as long as you limit your investors to accredited investors and you don't hold yourself out to be an investment advisor, which you're not, then you fall within the exemption. I don't have to do anything. In Texas, actually, you do have to file a little form, a truncated EEV, but most states you don't. So great, that's it. Check the box, done, right? But if somebody else comes in and they live in Washington or California, then that's different. That's a different analysis. You just need to make sure somebody's looking at the state where you live in to make sure that you are good, right? Some states couldn't care less. Pennsylvania is my favorite example. I've got a couple clients out there doing funded funds. As long as you don't do 15 of these funded funds, you're good. They don't care. Texas, not too shabby. They don't care as long as you've got only accrediteds. Massachusetts and those states start to get a little bit trickier because now they say, yeah, only accrediteds, but actually they've got to have $2 million in net worth. So technically they're qualified clients or purchase. I always get qualified clients and qualified purchases mixed up, but they're that. And then you go really crazy if you live in Seattle. Anybody live in the Washington area, they say you're fine, but you got to do $5 million in investable assets. Like that's a qualified, again, client or purchaser. I get those mixed up. So that's ridiculous. I mean, nobody's going to do that. So in that case, you're screwed in the sense that you're not going to fit within the exemption. So you're going to go register. And again, register is not, I'm actually going to, I don't know if he's here. I was considering, I'm starting my own investment advisory firm. It's not that good. So I'm either going to do it myself. I'm going to partner with somebody, but it's not the end of the world. Yeah. Oh, I got to go. Yeah. I got to go take an exam, but I probably should take a Series 65 and then just go through the nonsense of registering. It's not the end of the world. So anyway, that's that. The other big one is the Investment Companies Act, is because you're just basically a holding company and investing in other people. We've got to make sure you don't qualify under this Investment Companies Act of 1940, because if I do, I'm screwed. It's a very technical term in the legal world. If you're screwed, meaning you've got all these additional fiduciaries. There's limitations on how you can get paid and like no carry. Like it's just a mess, right? Not a big deal. If you have less than 100 investors, you're covered. Most of us are raising money from 20, 30, 40, 50, as long as there's less than 100 beneficial owners. So it gets complicated on the calculations. So once you get close, check with someone and you count. So it's really 99, or if you've got 54 co-sponsors, then you're down to 40, you're down to 45 LPs that you can have. But that's where most people qualify. It's what's called a 3C1 exemption. And then my big one, which, people have been trying to convince me that this is the least of their concern, and maybe, but I still worry about you not looking like a broker. You're not a licensed broker. You're not licensed to transact securities. I still get nervous when people just set up a structure and they just raise money specific. This is where the one-to-one comes in, Tim. This is my one concern about the fund-to-fund, where it's just one. I fear that the SEC will look at this and say, if I just get rid of the structure, at the end of the day, Tim, you're just raising money for Mauricio. Right. And yes, I've created a fund-to-fund, but at the end of the day, it's almost like smoke and mirrors. It's almost like a disguised commission. That concerns me. So I really want clients to do something. How are they adding value to the investor so that what they're getting paid for isn't just raising money for Bob, they're actually adding value. So again, if I can go down and fly down to the property and do my own walkthrough, that's a huge value add. And so just that's my only concern on the fund of funds. But other than that, I love fund of funds, and we're doing more and more of them. Like you said, we're coming out with a course on how to do fund of funds. I'm also getting a little bit more comfortable. Some people like to take the PPM from the underlying deal, right? And so that's how they try, and again, they're trying to make things simpler. So if I'm investing in Tim's deal, well, instead of me having to do a full-blown PPM and show them, like, why don't I just take Tim's PPM and hey, investors, here's Tim PPM. Okay, that works, but if Tim's PPM is not perfect, right? If Tim's PPM is only 70% good and he missed some disclosures over there, then I'm going to miss disclosures on mine. So anyway, I don't know how technical that was. If that was, really boring for most of you. I apologize. I like this stuff, but I can see that for some it may not be.
I love it. And it, it brings into the importance and the benefit of making sure you video document all the activities that you do in each of these deals. If you're going to go out there, do your due diligence, you do your research. When you're doing those, when you document those things, not only can you later on prove it to the SEC, but you can also use it in your social media, marketing as well, right? Because people always love to see case studies, and people love to see. You have to do it within.
No, let me tell you, that's my favorite. Let's just go with it, right? Let's just go with the flow. Let's just go where you're going. So that's one of my favorite content pieces. And I know we're kind of switching out of social media stuff, but this is my favorite content piece. When you're at a project, doing your due diligence on the project, bring your camera, whether it's your friend or iPhone or whatever, and then think of some content that you can do that adds value to your investors without talking about the specific deal or even reference people about your deal. And I've seen a bunch of them come out lately, and every time I see them, I'm like, yes, that's what it. So for example, hey guys, it's Mauricio. I'm here at, we're underwriting this, we got a new deal, whatever, we're underwriting. We're going to do walkthrough through all the buildings. And I'm going to walk you through the 5 things I look for. It's like my checklist that I look for when I go into these buildings. And then you go into the building. Well, first thing is I look at the washer and dryer hookup and make sure there's something there, because I can think. The next thing is I like to see if I can replace the kitchen cabinet, blah, blah, blah. And then I did, and that's a great video. Or here's the first thing I do when I show up at a property. I kind of walk around the edges or here's the parking lot. I saw one of our clients was doing a thing. And hey, the first thing I looked at was the parking lot, and I could see that, very little money, we could fix it, or maybe we can paint some lines and charge $20 for a parking lot. Those are all great value. You're not talking about your deal. You're not raising money. You're showing, first of all, you're showing them, at that point, you can probably say we bought this property, because ideally you're not going to show that during the raise, right? You're going to wait till your raise is done. So there's nobody that can even argue that you're somehow conditioning the market or trying to get people excited to call you about the deal. It's done. So then producing content that you can release 2 or 3 months from now about this particular, that's just a great way for you to show that you are an authority on the topic, that you know what you're doing, that you are an experienced operator, and you can learn, like, oh wow, I didn't even think of this thing, the washer dryer hookups, or when there's already a washing machine, there's been issues with the contract. How do you deal with contracts when you buy a new building and you've got to assume the laundry contract? Like, there's so much content you can do. You just can't say, hey, I'm at this building, we're doing a live or something, or that's coming out today, and it's like, hey, I'm here at the so-and-so building, we're in the middle of due diligence, and hey, if you want to learn more, reach out, because and then you try and sell them on the deal, right? That would be problematic. But adding value, the due diligence trip is a great one. Yeah,
that's really good. I want to circle back about the Investment Act of 1984.
I'm trying to take you away from it, but you're coming back.
Yes, I'm coming back to that, because okay, so if I was, let's say I'm gonna do 10 11, let's just use 11 SPV funds, and each SPV took on 10 investors, and now with 11 I have 110. Is that questionable? Because now I'm going, even though they're separate SPVs, so I am within that 99 investor rule, but because they're all individual SPV funds for one deal at a time, can that be looked at, of me trying to get around that 99 investor rule?
I mean, there is a possibility, if they're identical deals, that the SEC could what's called integrate them, like consider them, one, even though there's 10 different ones. But presumably, if those are 10 different SPVs and those are investing in 10 different buildings, that's not an issue. The way it really would be an issue is if you're buying one building and you're running into 100 investors and they say, well, let me break this up into 10 and we'll all buy 10% of the same building. That's not going to work. But if you're buying a completely different deal and it's a completely different risk profile, it's a completely different owners, everything's different. I don't know how the SEC would integrate those, but it's just when you try and get around. So it's a good point to bring up, but it would have to be literally, it's the same deal that I just decided to break up and own a smaller percentage just so I could get around the rule. And this, and your description, they're really 10 separate deals, right? Separate things.
Gotcha. Okay. Another question is, so assuming that I'm going to make sure all of my SPVs are for accredited investors only, can my SPV invest in a 506B syndication deal?
So if your fund is an accredited investor fund, because all of your investors are accredited, then you are an accredited investor for purposes of well, let me be careful there. You're an accredited investor for the underlying 506B, right? And the 506B can take an unlimited, not an unlimited, because at some point you got to go public. So if you got 2,000 investors, you got to go public, but let's put that aside. You can take in an unlimited amount of non-accrediteds, or accredited investors, sorry, and then you're just limited to 35 non-accredited. Where it gets tricky though is the other way around, which is, let's just say you have 10 non-accredited investors in your fund, because and you're saying you did a 506B, you took in 10 non-accrediteds, totally fine. When you invest in somebody else's deal, their 506B deal, even though you're one investor, there's a look-through provision. So even though it's only one investor, you don't count as one non-accredited. You're going to count as 10 non-accredited because they're going to look through that fund and to see the actual beneficial owners. But other than that, that's fine. Where it gets complicated is really where it really is prohibitive is if you're doing a 506B and you have non-accredited, so your fund is non-accredited, you would not be eligible to invest in 506C deals. Right. So that's the one that gets tricky, because the 506Cs can only take accredited. And so your fund's non-accredited because you have one or more non-accredited. So that would be the prohibition. The other tricky part is, and I haven't spent too much time on this, but it's just something that I'm aware of that I think you should be aware of, and you should be cautious about it and talk to your securities attorney if this is the scenario. But if you have a 506C deal, you're able to advertise, and let's say doing a fund to funds, like just one-to-one, you're able to advertise your deal, right, to bring in investors. But if you're investing in a 506B deal, they're not allowed to advertise. So you advertising about the 506B deal may cause some issues, especially for the 506B. Now it has to do with control and whether, how you do it. But that's something I would be wary about if you're doing a 506C and you want to invest in somebody else's deal. Just be cautious. Maybe you probably just want to check with their counsel and just make sure that it's okay for you to be posting about their deal on social, even though they're not allowed to advertise and you're kind of advertising on their behalf.
Yeah, you actually answered my next question. So perfect. Based on everything we talked about, and the industry coming to a place where there will be more and more capital allocators, right? Capital allocators, where our job, our specialty is to raise capital. What is the best structure that you recommend that we do? Should we do SPV funds? Should we do customizable funds? Should we do normal like this is gonna be a big one, which reminds me, I do want to get into customizable funds too. But let's assume for just a second that people know what
this is gonna have to be a 3-part podcast. I can tell.
No kidding. No kidding. Assuming everyone understands the different types of funds, what is the structure that you recommend that you think is most fit for someone who wants to specialize being a capital allocator?
Yeah. So I recently, if you're not on, I sent out an email today about the 6 different ways to raise capital. And the 2 that I like the most, although I must say, I talked to one of the industry leaders just last week, and he's now kind of convinced me that maybe the second one is not as, great as I thought it was, just because he was in the trenches. But so I think if you can fit under the state exemption, I think fund of funds, plural, is the best and safest way to go. So assuming you live in a state like Texas, like you're great. Like if you live in Seattle, I'm sorry, or Boston, in Massachusetts, that's going to be a little bit more complicated. But assuming that you live in a normal state, So Texas is a great example. Then I think a fund of funds where you raise money and you tell your investors, look, I'm going to raise $10 million, $5 million, and I'm going to use my relationships with all these amazing operators that I know are great. I've known them for years, and I'm going to do my underwriting for you. And I've got these opportunities, and I'm going to allocate the money into multifamily or whatever the asset class. I think that's by far the best way to go. The second one that I thought was, and I still, something to keep in mind is the other way you could do it. I would never recommend anybody go get a broker dealer license, because then yes, you could go raise capital, but there's so much regulation. But you could become what's called a registered representative, and this is where I was kind of pushing it last time. I've heard some pushback in the sense that there is still a lot of regulation, but the idea is that you get your registered representative, which is not that hard to get. Right. You pass a couple exams, and depending on, actually, if you're doing syndications, it's not even the Series 7. It's like the Series 22, I think. It's not the end of the world. You got to study, pass an exam, and then you hang your license with a broker dealer. And there's more and more broker dealers that allow syndicators like you and me to hang their license. And it just works the same as a real estate broker, right? You have a real estate broker, but you're working with an agent, right? And your agent's the one that's following you around. And when they sell the house, they get paid 6%. But remember, it's not the agent or 3%. It's not the agent that gets paid the 3%. It's the real estate broker that gets that. And then they split the fees with the agent. Same thing here. You would actually make the payment to the broker dealer, and then they would split the fee with you. And you're going to get 88% of that fee. But that way you're literally getting compensated to raise money, and you can take a commission, you can do that. So I think those are the two big ones. The fund of funds, one-to-one, it can be done for sure. And I think you just got to be extra careful and do some extra work just to make sure you're not looking like you're, an unlicensed, you've just set this up to basically avoid being registering as a broker. And then you have the customizable funds, I guess, is the other topic that's been coming up a lot lately. And I don't have a problem with custom. So let's just explain. So this is a fairly new thing, and I don't have a problem with this conceptually. And this is where, how do I explain this? It's just a regular fund, I guess. It's a blind fund. Investors get to choose which asset of all the assets in the fund that they want to participate in. So instead of being part of the fund where, like, if the fund buys 10 assets, which is a good thing, I would always think of it as, well, I get to diversify. I get to invest in the fund and investing in 10 different assets. I'm diversified. I like that. You have the option to say, well, I actually want to invest in property number 4 only. I like that property itself. I like the location. I like the particular purchase price. And so I would like to only participate in the profit or loss of number 4. And that's great. I have no issues with that model. I think the issue I'm having with the model, so I have no problem with the model. I think I'm having an issue with how it's being presented, which it's not cheaper or less time consuming. It's more complex and more time consuming because, and I think today was the day I made this post. Again, going back all the way from the beginning, and maybe we can wrap this section up on that, but right at the beginning, your obligation is to make the disclosures, right? Your obligation as a syndicator is to make sure you're disclosing all of the material facts at the point of sale. And the point of sale is when you exchange the shares for the money. So once they wire the money over and they come into the thing, at that moment, and it's an instant in time, it's literally down to the second. At that point, you have an obligation to give them all the material facts about the deal, all the risks and all the disclosure, which means that every time on a customizable fund, every time you introduce a new asset, right, into the deal, and now you're showing me that asset, when I invest in that fund and specifically say, I want to be allocated that asset, you have an obligation to provide me with all the material facts and all the material disclosures on that particular asset. Right. And so as long as you're doing that, as long as you have your attorney, reviewing that asset, reviewing your business plan, reviewing and amending, or really not amending, but creating an addendum to the PPM that says, hey, here are the specific risks. I know we disclose the risks in general in our fund, but now you're going to be a part of this particular deal. Let me tell you all the risks of this marketplace. Let me tell you all the risks of this loan product. I'll take the risk of this property. Let me tell you, let me make sure that my business plan has been properly vetted and it's clean. Then it's great. But you still have to have some legal professional review each asset class.
Gotcha. Yeah, we definitely need to do one just on customizable funds, or just all on funds, period. Right. So with this one consider as capital raising, we'll do one just on funds and all the all the intricacies in that. So With that, Mauricio, for those that are listening in and want to work with you, hire you, consult with you, learn from you, where would you like to send them?
You can just go to, actually, the easiest one is Ask Mauricio. I just set up that up. It's askmauricio.com. That right now will forward to sort of a little questionnaire for you on the website that then can reach me and we can schedule a call if you want. And then eventually I'm going to build that out into sort of literally a Q&A where if you've got a specific question, you're going to be able to enter it. But for now, if you just go to askmauricio.com, it'll forward you to the right place. Or I'm on LinkedIn. I spend a lot of time on LinkedIn. I try and give you my thoughts almost daily. And then, of course, my real estate community, the Real Estate Syndicator Live community, which is realestatesyndicatorlive.com.
Awesome. All right. Mauricio, thank you so much for doing this show with me today. Really appreciate you.
Thanks for having me, Tim.